go. Welcome back from lunch, everyone. Our next session is about to begin. We now welcome to the stage the Honorable Kenneth T. Cuccinelli of the Center for Renewing America, who will moderate a debate between Mr. Casey Mattox of the Americans for Prosperity Foundation and Mr. Brian Hauss of the American Civil Liberties Union. Apologies, Casey Mattox will be moderating the conversation. I am so sorry, I was giving you guys fake news. They will be debating the following. Resolved, Americans should support the administration's immigration enforcement actions at schools, colleges, and universities. I'll let y'all take it away.
Well, thank you very much, and thanks to both DFI and to the Federalist Society for hosting this debate. I'm going to try to keep my own comments brief because I am a moderator, and you're here to hear from these two gentlemen. So I'll briefly introduce the two of them. They warrant a lot more of an introduction than I'm going to give them, but you'll find their fuller bios on the FedSoc website as well. To my left, maybe the first time that statement has ever been made, is Ken Cuccinelli. Ken Cuccinelli currently serves as Senior Fellow for Homeland Security at the Center for Renewing America. He has been a litigator for about 25 years, or over 25 years, and previously served as Virginia's Attorney General from 2010 to 2014. He's also served in the federal government as Acting Director of the United States Citizenship and Immigration Service, and then as Acting Deputy Secretary for the Department of Homeland Security. And he's obviously a frequent media commentator. You will see him in many places outside of this panel. And so very glad to be able to have him with us. Brian Hauss, to my far left, maybe a more commonly used phrase. Brian Hauss is Senior Staff Attorney with the ACLU's Speech and Technology Project, where he focuses on free expression issues. Since joining the ACLU in 2012, he's litigated cases defending the First Amendment rights of writers, journalists, media organizations, activists, and others. And he's authored or co-authored numerous Supreme Court amicus briefs on First Amendment issues, including some that we've been on the same side on as well. And so I'm going to stop there and get to the questions. What we're going to do is we're going to have opening remarks from both of the two of them, and just brief opening remarks. And then I will start working through a list of questions, but I want you to be working through your list of questions and thinking about what you want to ask, because we hope to be able to have plenty of time to be able to do that. They've limited me to 5 total questions. We'll see if I stick to that. But so we'll want and need your questions. But I'm going to start first with opening remarks, and I think we're going with Ken first.
All right. Well, good afternoon. I want to thank DFI and Federalist Society for having us for this discussion, and for Brian. Brian and I have done some discussions before, and he's someone I appreciate appearing with. And thank all of you as well for your interest in this subject. Obviously, with my previous role as Deputy Secretary at Homeland Security, I have a special interest in the interplay between the First Amendment and immigration enforcement. And obviously, here we're focusing on educational institutions, primarily universities, though I'm sure we'll talk about K through 12 a bit as well. And interestingly, from my perspective, this is not an entirely settled area of law. So I certainly will not be taking positions at least not in every area, where I declare what I believe the law to be. Sometimes you will be hearing me declaring that I think the law is uncertain in this area. And the Trump administration's enforcement, something I support as a general matter, is going to bring and is bringing some of these questions to the fore. Brian's litigating one of them, and so he brings that experience to this as well. So a very open area, which I think also allows us to express some policy views about where we think things should land and maybe how to get there. So I intend to do a bit of that along the way here in the next hour as well.
Thank you for the introduction, Casey, and thank you, Ken, for agreeing to debate me here today. And thank you to DFI and the Federalist Society for inviting me to come speak with you all. I've spoken at many FedSoc events over the years, and I've always had a great deal of fun and learned a lot in the process, and I'm sure today will be no different. In the interest of disclosure, I should let you know, as Ken mentioned, that I do represent a number of the students who have been detained and placed in removal proceedings by the Trump administration on the ground that their speech, according to Secretary of State Rubio, undermines U.S. foreign policy interests. But I'm speaking here today in my personal capacity and not on behalf of the ACLU or of my clients. So if you have any complaints, please take them up with my wife. I think it's no secret that the Trump administration is engaged in a wide-ranging campaign to rein in perceived ideological excesses in academia. I'm not here today to talk about that. But one of the levers the administration is pulling to achieve its objectives is its power over immigration enforcement. Now, I think Casey, Ken, and I all agree that Congress and the President enjoy wide discretion when it comes to immigration. But I'm here today to argue that those powers are constrained in key respects by the Constitution, as particularly relevant here the First Amendment and the Due Process Clause. Now, since I'm a lefty civil liberties lawyer, it will come as no surprise to you that I believe that's a good thing. Not only because it is one of our proudest boasts as the country with the world's oldest still existing constitution, that we extend our fundamental laws protections to everyone within our borders, but also because the protections of the Constitution afforded to non-citizens strengthen our own commitments to the rule of law, the separation of powers, and robust public debate. As we'll discuss today, I believe that the First Amendment and the Due Process Clause prohibit the administration's actions targeting student green card and visa holders for detention and deportation because of their constitutionally protected expression in the United States, whether it's participating in a protest or writing an op-ed in a newspaper. We would never tolerate the government arresting our fellow citizens for engaging in speech protected by the Constitution based on cryptic invocations of foreign policy. And we should uphold those same principles when it comes to non-citizens lawfully residing in the country as our colleagues, neighbors, friends, and relatives.
All right. I'm going to begin first with a question to Brian, and this is probably going to be the question that I think might dominate a bit more of the discussion. So get right into the point you were just raising. At least some of the immigration enforcement efforts by the Trump administration have been explicitly based on speech or association of the people involved. Just yesterday, Secretary Rubio said that visa holders, we can figure out exactly what the framing is here, visa holders who are commenting on favorably the murder of Charlie Kirk should, quote, prepare to be deported, unquote. So what is the application of the First Amendment to government actions against non-citizens in the U.S. or those seeking to enter the U.S.?
So I think there's an important distinction to be drawn there between non-citizens seeking to enter the United States and non-citizens residing in the country. The Supreme Court has said that non-citizens seeking to enter the United States do not have a First Amendment right to object to their exclusion, although people within the United States who have an interest in hearing them come speak can raise objections on a right to receive First Amendment theory, although the Supreme Court has said that if the Secretary of State provides a facially legitimate and bona fide reason, that will often overcome those objections. I'm here today to talk principally about non-citizens inside the United States. It's my belief that they receive largely, not entirely, but largely, the same First Amendment protections as citizens. And I'll start with the Supreme Court case that I believe stands for that proposition. It's a case called Bridges versus Wixon. It was an attempt, I think in the early 40s, to deport a labor organizer under the Smith Act on the ground that he was affiliated, according to the government, with the Communist Party. The Supreme Court largely resolved the case on due process grounds. It said the government had not established sufficient to justify deportation that he actually had been affiliated with the Communist Party. But in the course of reaching that majority conclusion, Justice Douglas said that he could not be deported and the law should not be interpreted to authorize his deportation on the grounds that he had published labor writings advocating for a change of government in the United States. And what Justice said in regards to that is that freedom of speech and press is accorded to aliens residing in this country. And for the past 80 years, Bridges has stood for the proposition that fundamental First Amendment rights are extended to non-citizens. And as a result of Bridges, several lower courts have held that the government cannot retaliate or seek to deport or detain non-citizens in retaliation for their First Amendment protected speech. Now that's the doctrine in the case law, and I'll get to the exceptions and the caveats in a minute, but I also want to talk about where that comes from. Partly that comes from our history regarding ideological exclusion of non-citizens. And that goes all the way back to the founding of the country, or right after the founding of the country, the Alien Friends Act. This was a statute passed by the Adams administration together with the Sedition Act, that's why they're known as the Alien and Sedition Acts, that gave President Adams the unilateral authority to deport any non-citizens deemed dangerous to the peace and safety of the United States. And the Federalists sought to justify that power on grounds very similar to what we hear today. They said that because the admission of an alien is a favor, that favor may be revoked at the government's pleasure. And James Madison, the author of the First Amendment and much of the Bill of Rights, decisively rejected that argument in his report of 1800. He said, "It does not follow, because aliens are not parties to the Constitution as citizens are parties to it, that whilst they actually conform to it, they have no right to its protection. Aliens are not more parties to the laws than they are parties to the Constitution. Yet it will not be disputed that as they owe on the one hand a temporary obedience, they are entitled in return to their protection and advantage." And so I think those principles go all the way back to our founding, and they still apply today, and I think that's why the court in Bridges was right to hold that non-citizens have First Amendment rights. Just very briefly on the exceptions, obviously non-citizens do not have a First Amendment right to participate like citizens in the democratic process. That's a privilege of citizenship. Non-citizens can't serve on juries. They don't have a constitutional right to do that. They obviously do not have a constitutional right to vote. And the Supreme Court and Justice Kavanaugh, when he sat on the District of Columbia Federal Court, held that they don't have the right to contribute money to United States elections. My belief is that those decisions are cabined to the specific circumstances of democratic self-government. They are part of citizenship, and that's why the First Amendment protection does not extend to non-citizens there. But when it comes to other aspects of speech, when it comes to the ability to talk about public affairs, the First Amendment should still apply with full force.
So you all received some materials, and I would recommend the Volokh conspiracy article. Paul Clement talked about a report, and one of its great charms was how short it was. It was 2 pages. The Volokh article is very short, very blunt, and it breaks out areas of law, criminal law, entry into the country, et cetera, and addresses the application of the First Amendment in those areas. I think Brian and I agree that there's no point or legal position where an alien has less rights than when they are trying to get into the country. Once they're inside the United States, things do change. Which is part of why it's so important to do vetting up front, because from a simple matter of logistics and management, as somebody who used to address those tasks in dealing with an alien population, once they're inside the United States, you have an entire due process to undertake to remove them that you don't have on entry. I will concede that the Bridges case, Bridges v. Wixon from 1945, continues to be cited as the basis of expansive rights of aliens in the United States. I think it has been carved back some, only 7 years later, in the situation with a Communist Party member in Heresiades, if I'm saying the name correctly. Being a Cuccinelli, I'm a little sensitive to saying names correctly. But in the Heresiades case, and then another case, also Communist Party related, 2 years later in 1954, where the deportations were upheld, and alternatives to the First Amendment were rejected. Due process, for example, were rejected as alternatives for the alien to stay. So I think that the law is less than clear. I think there is an ascending scale of constitutional protections. The illegal alien gets the least, the legal permanent resident, I'm excluding citizens from the discussion, gets the most. I don't know whether that line is a parabola or a straight line. The court cases don't help us with the shape of that line very much. And in fact, in preparing for today, I found Ninth Circuit cases, only 4 years separating one another, where they said one panel was extremely restrictive on the rights available to aliens, and 4 years later, a different panel said they have virtually all the same rights as U.S. citizens under the Constitution. So when you look at this in the context of the Trump administration's enforcement efforts right now, where you have two things going on. One, you do have just plain old immigration enforcement, but where they're bringing in First Amendment issues doesn't tend to be with people who are here illegally. That's not where this is arising. It is arising in an educational environment or near the educational environment. For example, Khalil, who we'll talk about more later, I'm sure, had graduated from Columbia but was still engaged there. He wasn't a student. So there are nuances to every single case that come into play. Secretary Rubio has aggressively used his prerogative as Secretary of State to determine that some individuals threaten the foreign policy goals of the United States. That is a determination that's required to be made by the Secretary of State himself. He cannot delegate that finding. I would also note, again, from my former Deputy Secretary days, one of the things that happens because of that is when you actually have to deal with case by case, you are not building an entire system of removal around that process. You can't do it because you don't have enough of your Secretary of State's time, even if you could do the investigation on enough people that would warrant the consideration. So I do think we're dealing with the clash between First Amendment and removing aliens with a relatively small proportion of the alien population of the United States, a very small portion. And I also believe that when you see some of the other applications, First Amendment, we were talking before about a Sixth Circuit case decided yesterday in the election arena where Ohio's statute to forbid foreign funding, which included legally present residents, legally permanent residents, LPRs, green card holders, who under federal law can donate in federal campaigns. You may not know that, but federal law allows them to donate in federal campaigns. Ohio law now forbids them from donating to Ohio campaigns, along with all other aliens, and to referenda. And this is deemed a close call, including by the panel that upheld that law yesterday. It's the second Sixth Circuit panel to uphold that law. But because it was 2-1, again, I think that, interestingly, we may get a lot more light shed on the aspect of the alien situation as it relates to the First Amendment coming from some of those election law cases, where we may get some resolution that I would say doesn't necessarily exist in the law today, some clarity that does not necessarily exist in the law today in terms of the full application of the First Amendment to aliens in this country, may come from the election side rather than from the enforcement of removal side of things that we're seeing with, I almost said Senator Rubio, but Secretary Rubio, and of course the large-scale deportations being undertaken by the Trump administration relative to historical standards.
Brian, I want to see if you had any response to any of that before we move on to the next question.
Sure thing. I'll just be very, very fast. First, as a former Ninth Circuit clerk myself, it comes as no surprise to me that there are conflicting panels on the Ninth Circuit. Second, just briefly as regards Heresiadis versus Sean Hesse, and I share Ken's trepidation about pronouncing those correctly. My understanding is that in that case, the Supreme Court held that the non-citizen was deportable on essentially the same grounds that a citizen could be punished for speech under the Smith Act, that being an active member of the Communist Party advocating the overthrow of the United States government was sanctionable both under the criminal law and under the immigration law. And that's an outdated ruling from a First Amendment perspective, but it's my belief that Heresiadis was actually applying the same rule to the non-citizens in that case that it would have applied to the citizens. And lastly, I do agree with Ken that the amount of enforcement actions being targeted at lawful visa holders or lawful permanent residents for ideological reasons is mercifully very low. But the chilling effect that emanates from a few high-profile arrests, detentions, placement and removal proceedings can still be extremely wide, and that's partly because the administration itself is heavily publicizing these actions and warning non-citizens that if they engage in certain speech, whether it's criticism of Israel or as Casey mentioned earlier, statements denigrating Charlie Kirk or other anti-American statements, that can result in them losing lawful status, being placed in detention, and being removed from the country.
All right, so since you mentioned chilling effect, and I'm going to ask about the chilling effect more broadly on other people, right? So this sort of action, immigration action, a lot of people would say, look, this isn't just about the people who are being removed, it's going to impact the campuses generally. So especially immigration enforcement in the university context. There are going to be other people who are U.S. citizens, for whom this produces some form of a chilling effect, sort of changes the culture at the university and the ability to engage. How do we think about the chilling effect of this sort of enforcement action? And this is my moderator's prerogative, I'm going to toss in the fact that at least in a number of people have commented that even the situations right now, the small number of situations where the administration is raising speech association of people involved in some of these cases, maybe wasn't even necessary to have reached that point, that there were other reasons that the person might have been removable, but the administration went directly to include at least speech-related reasons. And the concern is that might produce a chilling effect. So how do we think about the chilling effect on other people involved in the university community as a result of these actions? We'll start with you, Ken.
So I did a spring fellowship at the University of Chicago, ironically in the Pritzker Institute, and I did laugh about it there too. But I spoke with a number of foreign students and who are in no danger of being in the category, they aren't in Hamas protests, et cetera, and so forth. In fact, they oppose that sort of thing. But there's no question that they view the potential for enforcement based on their expression as real. I did not, and I inquired and we had discussion, I did not find U.S. citizens who were deterred along similar lines. I did not find professors who were changing how they taught or what they said because of that. But it clearly does have an effect on other foreign students. If you're Secretary Rubio and your concern is for foreign policy, and you're dealing with one individual on a case-by-case basis, the individual isn't, under the statute, supposed to be the target of your concern. It's the foreign policy. And so I think that when Congress put that in place, they envisioned that there would be a strategic impact, I'll put it in national intentional terms, that was supportive of U.S. foreign policy, which is controlled overwhelmingly, of course, by the executive branch, and so can turn with elections, and we expect it to do so, and it has with the last election as well. So I do think there is some chilling effect. It is specifically on other foreign students. I've seen it myself. There's no point in denying that. It would be nice if it could be surgically targeted, but that's not, in fact, the way the law is supposed to work anyway. Legal standards are intended to apply to everyone under similar circumstances in the same ways. So other foreign students who see foreign students addressed because they've used what the administration considers speech and remarks and organization, call it what you want, that is counter to U.S. foreign policy interests, they take that into account when they consider what they're going to say, where they're going to say it, and how they're going to say it. That is part of the policy. That is not That may be uncomfortable. I think it should make us at least uncomfortable enough to ask questions about it, to decide how we think about that from a policy and a principle standpoint. But it is not a bug. It is a feature of that policy that Congress put in place and that Secretary Rubio is now exercising.
So I don't think it'll surprise any of you to hear that I absolutely believe that there is a substantial chilling effect going on at colleges and universities. I agree with Ken that the chilling effect is primarily and most acutely felt by non-citizen students and faculty rather than citizens. But the ripple effects of that chilling effect do actually affect the campus environment for everybody. First and foremost, classroom discussion and campus debate can't function properly when a significant portion of the academic community fears the consequences of making an argument or taking a position, say that the war in Gaza is a genocide, that would lead to their detention and deportation. It's impossible to know what people genuinely think about these propositions, whether you agree with them or want to rebut them, if they have strong incentives not to disclose their true opinions. And of course, many professors would rather not hold a seminar or an academic conference if it would meaningfully expose their students or colleagues to reprisals by the administration for attending or for views they might express there. I'd also point out that citizens do have some reason to be chilled because of the impact on non-citizens, and that's because non-citizens are part of our everyday lives as citizens. And so the Cato Institute has pointed out in one of the materials that was uploaded for this debate, the ways in which a citizen might be chilled. Should you bring a non-citizen friend or family member to a protest? Would you feel as confident protesting the United States government or an ally of the United States government if you knew that that meant a relative or close associate could be tarred with the same brush? Should you share articles critical of the administration's policy or the United States allies with non-citizens if their possession of those articles or if their reaction to those articles, say liking or resharing them on a social media platform, could be viewed as evidence that they hold a view that is in tension with United States foreign policy? And the chilling effect is compounded in this case, and we'll talk about this a little bit more later, because the foreign policy ground, the statute, provides no way of knowing what speech you might say could actually cause a foreign policy problem, and because many of the United States foreign policy interests are known only to Secretary Rubio himself. Is it safe for an economist to sign an open letter criticizing tariff policy? Can a historian write an op-ed criticizing Trump's policy toward Russia? Can a legal scholar publish a paper arguing that the administration has violated its treaty obligations? If the foreign policy ground is read to mean anything that touches on US foreign policy, that the Secretary believes somehow affects it, then it could potentially reach any of those things. And I would advise a non-citizen who asks me if it's safe to do those things, better safe than sorry. Because if you look at, for example, the case of Rumeysa Ozturk, she wrote an op-ed in a student newspaper that criticized the Tufts administration's handling of a student council government resolution relating to the war in Gaza. And that was the basis for which her visa was revoked, and she was arrested and detained in Louisiana, thousands of miles from her university, for several months before she was ultimately released. So people seeing what happens there, I think the only conclusion if you're a non-citizen is, it's very dangerous to talk about any hot-button issue that could conceivably touch on foreign policy. And I just want to talk briefly about the foreign policy ground's statutory purpose and intent. And part of this goes to the decision that the district court released in the Khalil case. And there, the district judge, Judge Farbiarz, analyzed the legislative history of the statute, dictionary definitions of foreign policy interest, and the enforcement history of the statute. And based on those things, he concluded that what the statute was really about is speech or conduct taking place abroad that had a concrete impact on America's relations with foreign countries. And so the two examples cited in the legislative history are the Shah of Iran, who was briefly in the United States seeking medical treatment when the Iranian Revolution happened. And it was felt that his continued presence in the United States at that time could endanger the lives of US citizens abroad. And that was one ground for which Congress enacted the foreign policy ground. The other was when a non-citizen's presence in the United States might violate a US treaty obligation. Essentially, a super extradition law saying that if we can't extradite them some other way, maybe the foreign policy ground could be a basis to extradite them. I don't think that Congress actually intended the statute to be applied so broadly that it would reach any non-citizen who is critical of American foreign policy or takes a position that is somehow inconsistent with American foreign policy. But because of the way the statute is drafted, now Secretary Rubio has claimed this power.
If I could broaden, I'm also on the Board of Visitors at the University of Virginia, and it would probably be remiss if we didn't at least touch on non-individual cases. So the Trump administration is also being aggressive with its financial leverage with universities where, particularly with the Hamas support expression, where the university is, in the Trump administration's mind, weighing in on behalf of the Hamas supporters at the expense of the civil liberties of Jewish students and those who oppose those pro-Palestinian positions. And they're using money to do it. So individuals aren't at issue here, but the question of expression and speech is still at issue with respect to these dollars. And frankly, the leverage is working in some respects. If you're the administration, you're getting neutrality policies, you're getting some changes of, at least on paper, of behavior of universities. At the same time, Harvard has taken them to court and has at least a district court ruling in its favor that this is not legally allowable. I can tell you, as someone who sits on a Board of Visitors where federal dollars represent, let me think, 12.5% or so of the entire budget, of the whole budget for the entire university and the hospital and the medical system and everything. That is an enormous chunk at risk. And we've not seen an administration ever before use that leverage in the direction, I'll speak of it ideologically, to force things to the right like the Trump administration is. And for those of you who were at lunch where Paul Clement spoke, he noted that academic freedom isn't worth much without academic diversity. And that doesn't exist in most universities today. And the Trump administration is using other tools, we might consider them rough tools, to achieve more freedom of expression, more openness, et cetera, really by pushing the universities in that direction, using the dollars available.
We've touched a little bit on the statute and the statutory protection or statutory authorization to the Secretary. So I'm going to skip our question 3, at least for the moment. Yeah. We'll move on to the next question because I think it fits here. So the statute, Immigration Naturalization Act, so this is, if you're reading along in your personal copy, your pocket copy of the INA, it's 8 U.S.C. 1227.
Then you are a geek, sorry.
Yeah, right, 4C1. Okay, so it states, an alien whose presence or activities in the United States, the Secretary of State has reasonable ground to believe would have potentially serious adverse foreign policy consequences for the United States is deportable. Is that provision, let's just cut to the chase, is that provision constitutional with respect to otherwise protected speech, and is it otherwise constitutionally deficient? And I will raise here the possibility of, I mean, it's a really broad grant of power. Does the Secretary believe it's inconsistent with foreign policy interests? So I'll leave that question there, and to the extent that you have thoughts on specifically what is the foreign policy interest of the United States that's at threat or under threat with some of these situations? So Brian, we'll come to you first. Your thoughts on the statute itself.
I don't think the statute is constitutional when it comes to deporting or removing non-citizens, whether they're visa holders or green card holders, who are lawfully in the country for their constitutionally protected speech in the United States. As we've already discussed, I believe that non-citizens residing in the United States have First Amendment rights, and that means at the bedrock of it that the government cannot expose them to punishments, including deportation, because it disagrees with what they have to say. And it can't do it based on the content of their speech or on the basis of their viewpoint of their speech. And it certainly seems like the justifications that Secretary Rubio has for invoking the foreign policy ground in these cases is that he believes that the speech of these students is anti-Semitic, is detrimental to America's interests, and on that ground, because of what they've said, he's deporting them. And so I think that's a straightforward First Amendment violation. And that's true whether or not the speech offends Secretary Rubio personally or it offends some of America's allies. In Booz versus Berry, the Supreme Court held that we protect speech if it offends foreign government officials just the same way we protect it when it offends domestic government officials or fellow Americans. And so in that way, I believe the statute is facially violative of the First Amendment. I also think it's unconstitutionally vague. And that's because, as you were alluding to, Casey, the statute provides no administrable standard for deciding whether a non-citizen is removable. It just says if the secretary determines in his sole discretion that they undermine U.S. foreign policy interest. There's no way of knowing what that means. And actually, President Trump's sister, Judge Marianne Trump Barry, when she was sitting as a federal judge in New Jersey, facially struck down this exact statute, the foreign policy ground, under the reasoning that it was unconstitutionally vague. She said it provides no standard for knowing what speech or what activity you engage in could result in your deportation. Deportation is a very serious penalty. The Supreme Court has held that because it's a very serious penalty, we impose strict vagueness standards in trying to understand when that penalty can be imposed. And so, for example, in Sessions versus DeMea, just a handful of years ago, the Supreme Court struck down a provision of the INA, the residual clause, because it said that after years of judges trying to figure out what it meant, they couldn't figure it out. And that's exactly the same problem with the foreign policy ground. And it also means that the non-citizen has no way of defending themselves. If you go to court, what are you going to say? The DHS official is going to hold up a one-page letter from Secretary Rubio, like they did in Mr. Khalil's case, and say the secretary is determined to be removable under the foreign policy ground. The government staunchly maintains that you can't cross-examine the Secretary of State on this issue, you can't introduce evidence on this issue. The secretary's determination, according to the government, is conclusive, so you have absolutely no way of contesting the charges or even meaningfully knowing what they are. And the third problem that Judge Trump Barry identified is that the statute violates the separation of powers because it unites within one person, the Secretary of State, the power to make the law, the power to enforce it, and the power to decide the case, because no court reviewing his determination can meaningfully do anything. And in this respect, it is exactly like the Alien Friends Act. As Madison argued in the report of 1800, could a power be well given in terms less definite, less particular, and less precise, to be dangerous to the public safety, to be suspected of secret machinations against the government? These can never be mistaken for legal rules or certain definitions. They leave everything to the president. His will is the law, but it is not a legislative power only that is given to the president. He's to stand in place of the judiciary also. His suspicion is the only evidence which is to convict, his order the only judgment which is to be executed. That is a core violation of the separation of powers, to place that tremendous power in the hands of one single individual. And it's not a trivial delegation, because in this case, there are millions of non-citizens in the United States who could be removed at any time, despite having lawful status, purely because Secretary Rubio has made this determination and without any ground for appeal. And just very briefly, I'll touch on what I think the foreign policy interest is that Congress was getting at, because there has been some debate over this. Judge Farbeers, as I mentioned earlier, said that what Congress must have been getting at is the United States' interest in its relations with foreign countries. So the things that could trip the foreign policy ground under the statute would be things that create a diplomatic problem for the United States. In the Massieu case, it was because he was a former, I believe, deputy attorney general in Mexico. His brother had been murdered. He was under indictment by the Mexican authorities. It was a huge political situation in Mexico. Mexico very badly wanted him extradited. They failed to provide evidence to convince the US courts that extradition was permissible, and so the foreign policy ground was invoked. That itself, I think, shows why the statute is a violation of due process. But even putting that aside, at least that interest is more cabined and narrow than what the administration is claiming here, which is that any concern that relates to America's policies around the world, and there are innumerable American policies that apply around the world, any concern that touches on those is a legitimate interest for the foreign policy ground to apply. Any speech that undermines that interest in any way renders the non-citizen subject to deportation, and that is a shockingly broad power for the Secretary of State to possess.
So I would agree with Casey's characterization that this is a broadly worded authority on the part of the Secretary. The Secretary has stated that in the Khalil case that the foreign policy rationale was condoning anti-Semitic conduct and disruptive protests in the U.S. would severely undermine a significant foreign policy objective, which he described as championing core American interests and American citizens, American values, to kind of summarize it. And, this is one where First Amendment rights of non-citizens come into conflict with the extraordinary deference the executive branch gets in all matters under the umbrella of foreign policy. And where that should land, if I'd written the statute, I wouldn't have written it the way it reads today. But I do think that some authority on the part of the Secretary of State to address this topic is appropriate. Again, we now have a president with an administration that appears intent on being as aggressive as the law allows. And I think we're going to flesh out what the boundaries of that are here in the next year or two because of cases like this. And frankly, I think we're going to be better off in the long term for having done that. Obviously, most people with both of these organizations strongly believe that clarity in the law is a good thing. And regardless of what we think of the policy implications of a particular legal position, clarity provides certainty to individuals, whether they be citizens or non-citizens, and they also cabin the behavior of government officials. And I would agree that this statute is worded in a way that makes it harder to defend. And what I would suggest if I was counsel to the Secretary is that would lead me to be more particular in laying out my case for exercising the authority. And because that is obviously can be an as-applied approach that any court would look at on a case-by-case basis, and that I think they will look at on a case-by-case basis. A point I'll make later that I make, and I know there are some young lawyers in here, one thing you were never taught in law school was that every case has a burden of proof. You were taught that, but that proof has to be made and demonstrated to a live human being we call a judge. And so every case also has a burden of persuasion. Now, I'm a left-brain guy. I was an engineer at UVA. I didn't go to law school there. I went to the Antonin Scalia Law School, properly named now. And I'm a left-brained guy, and it's easier for me to step away from heartstring decision-making. But human beings are human beings, and judges are human beings. And if you want to make your case as strongly as you can, you don't make it coldly and surgically, you make it humanly. And you account for the burden of persuasion that's required. I don't know that the administration accounted for the burden of persuasion that they were going to be confronted with in how they executed this authority in some of these cases, including one Brian is dealing with. They could have put themselves in a better position for the foreign policy deference versus First Amendment contest that these sorts of cases naturally include, and that there is no escaping.
Yeah, I'll just aside, I'd realize that there's obviously a debate about whether or not we apply the non-delegation doctrine or major questions, any of those things in the context of something like this. But boy, asking the Secretary to state whether or not this is difficult for American foreign policy interests seems like a challenging, intelligible principle.
So I would note, just for the record, if you will, that the administration also says in the Khalil case that he was not forthcoming and fully answering some of the questions when he was obtaining legal permanent resident status. That is an alternative basis that they're arguing. I don't know those details, but having run the United States Citizenship and Immigration Services, where those applications are processed, about 1 million a year roughly. Those are obviously serious allegations that would also have to be overcome because they would serve as an independent basis for removal, though not using the same authority necessarily.
Well, maybe this is a good question, actually, off script slightly, but since you've commented there, it does make me, so Brian, I'm curious for your thoughts on how that would work. Say you have an otherwise valid basis for removal. It has nothing to do with the First Amendment. Mm-hmm. And then you also have the speech components, and they are both identified as a basis for removal. Mm-hmm. How does the law work in that context, where you have it's a both and?
Yeah, so I think in those contexts, the non-citizen does have a First Amendment retaliation claim against the facially legitimate ground. And in the Khalil case, for example, I think the equities are strong in favor of such a claim. I don't think you'll be surprised to hear me say that, because partly they filed the foreign policy ground as the sole basis for arresting and detaining him. Then a week after the habeas petition was filed, that's when they come in with this post hoc document charge and say, oh, and we also found some stuff with your green card application. Now, we dispute the accuracy of the government's charges with regards to those document fraud charges unequivocally. But even if they were valid, I think the fact that the government brought that charge after targeting him specifically under the foreign policy ground shows retaliatory intent. And I want to talk about this briefly because it does get into a somewhat tricky area of the law. An Arab American Anti-Discrimination Committee versus Reno, the Supreme Court, that was the case where the Los Angeles 8, a group of Palestinians living in the United States, were targeted for deportation. When the initial grounds, I think, for the deportation failed in court, essentially the Attorney General said, find me a different ground, and they found a different ground. They challenged that and went all the way to the Supreme Court. The majority of the case is actually about a statute that Congress passed in response to that case that said that you can't challenge certain actions in removal. You can't challenge the initiation of removal proceedings. You can't challenge the prosecution of removal proceedings. And so it was about that bar. But in a coda to the opinion, Justice Scalia said, essentially, and we don't have to worry that the application of this jurisdictional bar would prevent the non-citizen from raising a valid First Amendment defense, because generally, non-citizens in the country who do not have, if they're unlawfully in the country, if they start off being unlawfully in the country, they don't have a selective prosecution defense against removal. We don't look behind DHS's justification as long as it's facially legitimate. But the Supreme Court said that is subject to an outrageousness exception, and that in circumstances where the targeting was especially outrageous, a retaliation claim might lie. And in fact, lower courts, for example, the Second Circuit in a case called Rogbeer versus Homan, found that when DHS targeted non-citizens who were unlawfully in the country and tried to remove them, because it was clear from the record that DHS was doing that in response to their constitutionally protected speech, their criticism, essentially, of ICE policy, that was outrageous discrimination, and they did have a First Amendment claim under the exception the Supreme Court recognized in AADC.
So if you live in the Second Circuit and you're here illegally, put a poster in your yard criticizing ICE, and you, unless it goes to the Supreme Court, you're in good shape, you won't get deported. You know, this can become circular at a certain point. And selective prosecution with the outrageousness exception accepted has been one of those areas that there have been strong distinctions between how the rights of citizens and the rights of non-citizens, particularly as it relates to deportation. I got asked in one interview recently, I think it was after the Georgia Hyundai site raid, you know, how do they pick this site? And the reality of the logistics of it, first of all, there's so many millions of illegals in this country that you know, this administration isn't coming anywhere close to having to worry about that problem. That you go through your investigations, and whatever crosses the threshold with the prosecutors first, and where you have the logistical support, meaning the number of officers available you would need, et cetera, to just execute the operation, tends to be what determines when and what happens in the enforcement side when you're pressing ahead aggressively like this administration is. That doesn't mean they're not also, in say a Khalil situation, they have other goals that they're pursuing on an individualized basis at the same time. They're walking and chewing gum at the same time. Some of these are much more clearly within the boundaries of deportation authority than others. You know, we talked about the Khalil situation, for example, but there's no question that with an administration such as the second Trump administration, the first Trump administration wasn't this aggressive, that you're going to see an awful lot more of those kinds of conflicts where people are making other explanations or arguments for why they shouldn't be removed, and it can become, no offense to the lawyers defending them, it can be a stall tactic, kind of waiting out this administration. And depending what circuit you're in, et cetera, it can affect your strategic decision-making as to how to defend or bring those cases. So, you know, this is a messy area, the removal of illegals, and we've let it become such a bad problem over many years that the resolution of what level of constitutional rights they have will actually help smooth that process, because it'll bring the certainty that keeps lower courts from going their own way, that keep appellate courts from going their own way, and that keep the Second Circuit from being different than the Ninth Circuit, which is also important when you're talking about implementation of a national policy.
I'm going to, so first of all, I'm a liar because we don't have nearly enough time for all the questions that I'm sure you probably have. But am going to ask you to start coming up to the microphone so we can at least try to get a couple in. And while you do, I'll ask for just short answers on this thought. Plyler versus Doe, right? Plyler had said, Supreme Court had said that a state could deny people who were here illegally a K-12, or that states could not deny those students
right.
a K-12 education. Do you think Plyler would be decided the same way today? And are there implications for that in this context?
So I would urge you all to at least read the Plyler majority. It's in your materials. The Plyler majority said you don't have a fundamental right to an education. They said that being here illegally was not a suspect class, and then proceeded to decide the case on some sort of intermediate basis of review instead of a rational basis review, which most subjects touching on illegal aliens get. I do not think Plyler v. Doe would be decided the same way today as it was in 1982. It was 5-4 in 1982. I think that the biggest legal difference would be that this Supreme Court would apply rational basis review, where that court did not, as a practical matter, and you would get a different outcome. I think that the likelihood of it being challenged is it's going to have to be very intentional. You're not going to stumble across a Plyler v. Doe challenge. You're going to have to actually build it out. And in the Texas law at issue allowed localities to either deny access to the schools to illegal alien children or to charge them tuition. Back to my point about persuasion, there's at least 4 reasons I think that the way to challenge, to revisit Plyler, is to go the tuition route. I live in Spotsylvania County, Virginia. Wherever you live almost certainly does the same thing. For a kid who wants to attend Spotsylvania schools who lives in Stafford County, they pay tuition. And this is consistent with the 1996 federal law with respect to in-state tuition at colleges, which this administration is also now enforcing. that requires the charging of illegal aliens who may live in Virginia out-of-state tuition. Now, Virginia hasn't been one of the states who's settled yet, but Texas and Minnesota have. And I think that approach addresses the problem in a manner that's consistent with how local schools already operate. It's consistent with the federal policy I just referenced for the college level, though there are reasons to think the college versus K through 12 distinctions would continue to stick. It also addresses the cost problem, which is a real one for states and localities, though the majority in Plyler dismissed it, saying that no evidence had been presented that this would make a material difference in that regard. And then fourth, if you leave a way in, like tuition, instead of excluding people, you're more likely to win over judges.
Brian, if you have a quick response, then we can get our one question at least.
Sounds good.
Yeah.
I'll be the first to acknowledge that Plyler did not fit neatly into the doctrinal boxes that the Supreme Court has set up for the Equal Protection Clause, and that its rationale likely would not resonate with several members of today's court. I nonetheless think that Plyler was rightly decided. And to me, the key point about Plyler is that undocumented children will suffer the rest of their lives if they are denied equal access to public education because of an immigration status for which they are not responsible and that they have no power to change. If they are not removed from the country, which is the president's prerogative, but we know for a fact that many of them will not be, they will become, as Plyler predicted, an illiterate underclass locked out of meaningful participation in the labor market and forced into exploitative commercial and sexual labor. To me, the Equal Protection Clause stands against precisely the sort of status-based discrimination that creates such an underclass. But because we're at FedSoc, I can't resist providing an alternative ground that might appeal to the conservatives on today's court. Steve Calabresi's and Lena Barsky's article, An Originalist Defense of Plyler versus Doe, argues that the original meaning of the Equal Protection Clause was intended precisely to protect undocumented people, non-citizens, including those who are here illegally, and to provide them equal shelter under the law, including with respect to education, which was widely recognized as a right at the time that the 14th Amendment was ratified, and that because the 14th Amendment extends its protections to all persons within the United States, that protection applies to non-citizens, even if they are here illegally.
Yeah, I would just, because I don't think you'll all take my advice and read Plyler's majority. They gave three reasons. Brian touched on one, the innocence of the children involved. They did not make the decision to come into the country illegally, and they shouldn't suffer for it. The second was that education is a foundational element of a democratic society. And third, that the concern about creating a permanent underclass, as Brian referenced. I would note that, first of all, their first point is true. The children didn't make the decision, their parents did. But the second two are logically inconsistent, that in the sense that they both presume that the law will not be enforced. Both of them. They presume the children will be here forever, will grow up here in, however long, and live their lives here. And for the Supreme Court of the United States to presume that the law won't ever be enforced, and that that's a reason to decide a case like Plyler in the manner they did, strikes me as institutionally problematic.
We're going to go to our one question.
Thanks so much. All right, this may be a perfectly terrible idea, but I understand from what you said earlier that, say, if you're vetting someone for a visa and you find they have a social media history as a, pro-Palestinian activist, you can deny the visa. And when you talked about lying on the application, I assume you mean not anything ideological. They lied about who they were, where they lived, or something along those lines. Can you put conditions in the visa, in the visa application, that could change from time to time, but would reflect the current hot button issues with respect to ideology, even asking them, say, you have to come into the country committing that you're not going to take positions publicly on certain issues. That's a suggestion from someone who's a little concerned about this.
So I'll take it in pieces. First of all, whatever conditions, whatever documentation is filled out, once you are let into the country, you are in a different posture with respect to the protection of the Constitution than you are prior to entry. And that difference is very significant. And I don't just mean important, I mean it's dramatic. It's a big difference in protection. It's very difficult to challenge entry under almost any circumstances. I won't say 100%, but it's awfully, awfully tough. Whereas once you are in the country, even if you've lied to get into the country, there's still a process to demonstrate whether or not you lied to get into the country to remove you. This presumes you're, within the boundaries of a visa. And even if you enter illegally, as you all know, you have substantial due process that takes place before removing you. So I don't think, in the absence of congressional action, because I will say the Supreme Court has, throughout the last 100 years, frequently made reference to the plenary power of Congress in this area. It was a big part of the Heresiades case, was Congress had actually put in place a statute to address Communist Party membership, however appropriate that may have been. But that's something that the court takes very seriously. And it is not something you're used to hearing in other types of cases, because there aren't many things that are where Congress has plenary authority like that from the perspective of the courts. So,
Brian, you get the last comment.
I largely agree with Ken in the sense that I think the executive does have very wide discretion to decide not to let someone into the country, and that when you're outside the country, you just don't have First Amendment rights. But once you're in the country, you have them. And I don't think you can create a conditional entry where you say you can come into the country as long as you forfeit your First Amendment rights while you're here, because once you're here, the rights attach, and then that condition on your speech becomes invalid while you're here. So in that respect, I think those conditions attached to a visa, saying that you promise when you come to the United States not to do these things, that promise could not be judicially enforced once you're here.
Right. Well, thank you to DFI. Thank you to the Federalist Society. I think we are now illegally present on this dais, so I think we need to evacuate.
To get us out of here.
But thank you, all of you, for being here.
Another round of applause for our moderator, Mr. Casey Mattox, and our debaters, Mr. Brian Hauss and the Honorable Ken Cuccinelli. So we have had one brief addition to our program today. At this time, I actually invite you to remain in your seats for a screening of the Federalist Society's upcoming Title IX documentary trailer. And at the conclusion of the trailer, author David Swag will be signing copies of his book, An Abundance of Caution, in the anteroom just outside those doors.
Title IX and sexual assault on college campuses are no stranger to the polarized news cycle, making it difficult to separate facts from clickbait. One side talks about not protecting women.
Schools are more interested in protecting and covering up rapists than they are about having women seek justice.
While the other side talks about men's rights being ignored.
This is a war on basic fairness in college. It's a war, let's be clear, essentially on men.
For over 50 years, Title IX has been a law intended to protect all students from discrimination on the basis of sex in educational settings.
It is called Title IX, and it says, no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any educational program or activity receiving federal assistance.
Admissions has been a source of flagrant discrimination for years. This eliminates all that. It's a tremendous barrier that's been dropped.
But over the years, those 37 words have been stretched, tested, and asked to do far more than their authors ever imagined.
It has morphed significantly to encompass sexual harassment, sexual misconduct on campuses.
There's been a political game played with campus sexual assault. In Title IX, as a survivor, I can say nothing is more offensive.
As a university professor, I've taught on college campuses for almost 30 years, and I wanted to better understand how changes in Title IX regulations affect students. So first, I read everything I could get my hands on about the law.
Please be in order.
Then, my film team and I packed up our cameras to talk with randomly selected students and recent graduates all across the country.
You said you went to UT, right? Are you both at UT? Yeah, we're both seniors. Brian, Nicole, take one.
I'm kind of nervous about these questions.
We also invited experts across the political spectrum into the conversation, including survivor advocates.
I don't think that Title IX is the answer. I think that we have to do more work.
And attorneys working on the front lines.
I think sometimes the actual kids on campus are the casualty of the big narrative war.
Because we wanted to know, if we focus on the facts, can we find common ground on this essential issue?